Hey guys, welcome back to my channel, Contracts Unfolded. Now, continuing our boilerplate clause series, today we will be discussing about two other important boilerplate clauses, which are the governing clause and the dispute resolution clause. So, let's start with the governing clause. So, this clause basically determines which legal system will interpret the contract. Now, imagine this scenario. An Indian startup signs a SES agreement with a company located in the United States. Now, after some time, a dispute arises because of the payment and because of the service quality. Now, the question is, which law applies? Is it the Indian law or is it the US law? And this is where the governing law comes into picture. So, if the contract says the agreement shall be governed by the law of India, then the Indian legal principles will interpret the aspects mentioned in the contract. And this matters a lot because different legal systems interpret legal things differently. For example, certain clauses such as limitation of liability or non-compete clauses can be viewed differently in the Indian legal perspective, and they will be viewed differently in the US perspective or the English law perspective. And therefore, choosing a governing law is not just a mere formality. This clause directly determines how your rights and obligations will be interpreted. Now, let's move to the dispute resolution clause. And this clause basically tells how and where the dispute between the parties will be resolved. There are two common ways to do it. One is litigation, where the parties go to the court, and the other is arbitration, which is a alternative dispute resolution method, which basically means that the party can settle their disputes without even going to the court. Let's understand this with the help of an example. So let's say two parties enter into a contract and a dispute arises over the payment. Now, if the dispute resolution clauses says that the dispute shall be resolved in the courts of Mumbai, then the parties must go to the court of Mumbai to solve the dispute. But if the contract says the dispute shall be resolved through arbitration, then the matter will go to an arbitral tribunal instead of a court. Now, let's understand this with the help of an even more complex example to understand why there is a need of an arbitration in the dispute resolution in the first place. So let's say an Indian company and a company based in Singapore enter into a contract, and again the party got into a dispute over the payments. Now, it will be very difficult for the parties based in the Singapore to fight the case in India, and similarly it will be very difficult for the parties based in India to fight the case in Singapore. And again, let's say the Indian court passed a judgment, then it will become very difficult to enforce that judgment in Singapore, and therefore to tackle such kind of problems between intercontinental agreements or contracts, arbitration comes into picture, because there are many countries which are part of the New York Convention, and which basically says that if an award will be passed in a country, then the other country which is part of the New York Convention will have to enforce the outcome that has been passed by the arbitral tribunal. And therefore, arbitral awards are much easier to enforce globally in comparison to the judgments of the award passed by the courts. And therefore, these two clauses together affects the cost, affects the speed, affects the convenience, and affects the enforceability of the contracts. Now, let's talk about one of the most common drafting mistakes related to these clauses, and that is treating these clauses the same. However, as we just saw, it is not the case. While the governing law tells which law applies, the dispute resolution clause actually tells where and how the dispute will be resolved. But I see in most of the contracts, the parties only mentions about the governing law, and there is little to no mention about the dispute resolution method. And when the actual dispute arises, I see the parties sending emails, notices to each other saying, let's just go to the court of Mumbai for the dispute resolution. And the other party saying, we are located in Delhi, you come down to Delhi. Now, all these troubles can be tackled if you clearly mention in the contract the dispute resolution clause, where and how the disputes will be resolved. So that's it for this video. Now there is a lot to cover about the dispute resolution clause or the arbitration clause, and we will definitely make a comprehensive video in the future, but to keep it short this time, this is what all I have for this video. Thank you so much for watching. Thank you so much for your time.